record, this is the Senate Judiciary and Public Safety Committee, and today's date is Wednesday, March 9th, 2022. We have two bills on our agenda today, and they both are considered to be layover bills. We will not be taking votes on them for any type of final passage. Senator Newman has the first bill. He's in the audience, and he's approaching the testifying table. Senator Newman, you have Senate File 3224. You can proceed at will.
Thank you, Mr. Chairman and members. Senate File 3224 is a fairly easy bill, I think, to understand, at least in terms of the idea. The essence of the bill is to try and reach an appropriate level of punishment for those, the worst of offenders who are violent, or those habitual offenders who continue to commit felonies, although maybe not violent felonies, and continue to walk among us and live among us even though they have repeatedly committed felonies. So what this bill proposes to do is to make Minnesota's version of the three strikes law mandatory rather than permissive. First, it would require that when a judge is dealing with a violent criminal, that the judge must improve the full statutory maximum allowed after the third offense if the public is at risk of further harm by the offender. The other part is the habitual offender, and that comes in keeping where an individual through the same pattern of conduct and with the sixth and latest felony has a prison commitment on the sentencing guideline grid whereby the judge must commit the person to prison for the latest felony. In either of these cases, three violent felonies or the sixth-time habitual felon, the bill requires that the sentence would be longer, probably with a consecutive sentence rather than concurrently served, and that prison time must be fully served under the new sections in Section 4 and 5. I think that the bill, in essence, is trying to send a message to both the county attorneys and to the judges who are elected officials that they have to do more to protect the public from these violent or repeat felony offenders. And I just would like to give you an example, for instance, with the violent offenders, the types of crimes that we are talking about, whereby a judge would be required to send the individual to prison. And this isn't a complete list, but just an idea of what we're talking about. It would involve crimes with involving methamphetamines, that involve children and vulnerable adults, felons who are illegally in possession of firearms, murder, criminal vehicular homicide, crimes involving great bodily harm, involving the distribution of drugs, robbery, and remember, robbery is a personal crime. It isn't a property crime. It's where somebody is robbed of their possessions, and even if they're not hurt, robbery does leave a scar with the victim. This involves kidnapping and false imprisonment, sex trafficking, criminal sexual conduct, drive-by shootings. There's a crime that I totally don't understand. In my mind, you commit a drive-by shooting, shooting at your neighbor's home, or there's children or whatever, they should go to prison the first time. Or a felony committed in the benefit of a gang. And again, those are just some examples, Mr. Chairman. The bill increases incarceration, mandatory incarceration. And I want to give you 4 different reasons as to why that would be appropriate. First of all, there seems to me there should be consequences for bad behavior. And that type of logic, I think, could begin with when we are raising our children all the way through these criminal offenses. Consequences for bad behavior is in my mind, a pretty normal response. And so if there is a consequence for the violent crimes or consequences for a felon who commits 6 felonies, that consequences should be prison time. The bill would involve the removal of a convicted felon from society. And I think that that's a legitimate reason for sending somebody to prison, at least until we know that they can walk among us without committing more crimes. There is the element of deterrence, and there's a lot of people that argue both sides of that issue, that it is or is not a deterrent if people are sent to prison. I would argue that it is, both a deterrent to the individual who has committed the crime and a deterrent to others who have witnessed that individual having to go to prison for his wrongful conduct. And then finally, the issue of rehabilitation. Rehabilitation to become a law-abiding citizen as a result of having to go to prison, I think is a legitimate issue. And I'll share with you a very quick personal story to try and illustrate what I am talking about. There's a friend of mine in my Senate district who was a very young man, really got off the track and committed a number of crimes such that he wound up in prison. And while he's sitting in prison, he had to give some thought, what is he going to do with the rest of his life? Is he going to continue to be a criminal and spend his life in prison? Or is he going to try and make something of himself? Well, today he's a middle-aged man. He has a family, he has children, he has a job, he's a model citizen. And I would argue, and I think the point of my story is, that that stint in prison had an effect on his life and helped straighten him out. And so I would argue, Mr. Chairman and members, that you're not always doing a favor to the violent criminal or the repeat criminal by failing to send them to prison. Because if you don't send them to prison, you are not providing an opportunity for them to have that epiphany that this friend of mine had and straighten out their life. Mr. Chairman, that is the essence of the bill. I will most certainly try to answer any questions that the committee may have. And I do not have any witnesses, Mr. Chairman.
Right. Thank you, Senator Newman. As you said, we have no testifiers. Is there anyone in the audience who wishes to speak for or against this bill? Hearing none, we'll proceed with open discussion and questions from our committee. Senator Latz.
Mr. Chairman, I guess I'd like some clarification here. Obviously, this takes away judicial and prosecutorial discretion in terms of recommending sentences and trying to fashion a sentence that's appropriate to any particular case. Trying to imagine some circumstances here where this would have an impact. And, there certainly are plenty of cases where it would be the right thing, or prison time is the right thing to do, and where upward durational departures are the right thing to do. But I'm looking at, for example, the 6th felony provision. If I'm reading this correctly, if someone commits a series of thefts for that are felonies, meaning whatever they stole was $1,001 or more. So 5 small TVs, and then they do steal a 6th small TV. Now, this would have to be a nice flat screen, I suppose, to be $1,001, but, you know, if that's what it is. And then, what kind of prison time are they looking at for committing 6 felony property thefts?
Sir Newman?
Mr. Chairman, Senator Latz, off the top of my head, I can't tell you. I would defer to Mr. Backus to answer that specific question. However, I would indicate that after 6 felonies, we're dealing with someone who needs a lesson. And in my mind, after 6 felonies, even though they are, I think you are indicating maybe they are not real serious felonies. After 6 of them, yeah, I think that individual should go to prison.
Sir Love?
Mr. Chairman, maybe Mr. Backus can help me out here with an answer. I know it would depend on how old the felonies were and so on, whether any had degraded off of the chart for criminal history and under the sentencing guidelines and so, but let's assume they all count. Let's say he does 5 within 5 years or something like that. Doesn't take much to get to $1,001 in terms of a piece of property. So can we give some idea? I mean, we're talking about, prison means, prison, it means you're not going to the workhouse. So you can go to the workhouse for a year under current requirements. But if there's no discretion on the part of the judge, then you're talking prison, that's a consequence. So is workhouse for a year as a consequence. But what would be the prison sentence under circumstances like that? Any idea, Mr. Backus?
Mr. Backus?
Mr. Chair and Senator Latz, I really can't answer that sitting here. It would depend obviously on the prior offenses, and I just, it would take a while to kind of work that up in terms of what the person's criminal history would be. But just to clarify, that portion of the bill provides for the mandatory sentence. It's based on it has to be based on a presumptive imprisonment sentence. So the person would be presumed to go to prison to begin with under the bill. And then the bill simply requires that the judge impose an aggravated durational departure, but it doesn't specify what that durational departure would be. So that part would be up to the judge, but it would have to be above the cell duration.
Don't, Mr. Chairman?
Sir Lance?
I assume the same situation might apply if we're dealing with, say, criminal damage to property, which would be property in the first degree to get to a felony, or actually, I think it's a felony also if it's a bias-related criminal damage to property. But let's say let's say they don't have any violent crimes against persons, but they got a history of breaking large plate glass windows, which would easily exceed the $1,000 cost of repair, which is the threshold for a felony criminal damage to property crime. And if you've already got a presumptive commit, and sometimes the negotiations might be, well, we'll agree to sentence to the bottom of the box, because there's a range in every sentencing guidelines box, and there's a bottom, there's a midpoint, and then there's a high point, and what this is saying, this bill would say it has to go above the box into a durational departure upward. Aside from the fact that it kind of completely undermines the sentencing guidelines system, because it defines this. The judge doesn't even have to look at all the criteria for a durational departure. It's just the statute says you got to do it regardless of the circumstances. Even if they don't meet any of the other typical durational departure guidelines, the statute would say judge has to sentence that person to an upward durational departure. But Senator Newman, wouldn't this also apply to someone who's got a history of breaking plate glass windows and they do it for a sixth time? And they're looking at not only prison time, but a duration of prison time that's above the presumptive range?
Senator Newman.
Senator Latz, 6 felonies? 6 felonies? And you
Six
haven't learned your
plate
lesson
glass
yet?
windows worth
it-
$1,001 or more.
The only way I can answer that question, Senator Latz, is that if you've got an individual who has committed 6 felonies, there are 6 victims at least. And at some point, a person has to learn their lesson. If it's going to be prison, fine. It honestly wouldn't take me that long. I have lived a long life and haven't committed a felony yet, let alone 6. So, I understand what you're trying to point out, and that would be to be minimizing the felons, or the felonies that are potentially being committed. And all I can tell you, Senator Latz, is I don't agree. If you cannot figure it out after 6 felonies, perhaps it's time that you go to prison.
So, Mr. Chairman,
Senator Latz.
Senator Newman, I think you're drawing the wrong conclusion from my comments. Not that I'm trying to minimize,
I apologize then.
not that I'm trying to minimize the conduct or the seriousness of their conduct. But what I am suggesting is a statute like this imposes a one-size-fits-all mandate on every circumstance. And that 6 felony property crimes would be different than 6 felony violent crimes along the list that you described earlier. But let's say someone's got a violent crime history, but the most recent one that would trigger that 6 is a broken plate glass window. I mean, does that mean, this would not give any participant in the process the discretion to do anything other than not just put them into prison, because there's already, as Mr. Back has pointed out, that's already a presumption in the statute. Okay, they already have to be presumed prison time. This would bump them up from the presumed grid to a durational departure upward. And that's the problem with these 3 strikes you're out laws across the country. We've seen that, where people, depending on how those laws are fashioned, they commit a comparatively minor offense. I pick property crimes intentionally because they're comparatively minor. They're not person crimes. They're not someone, brandishing a firearm or a crowbar and hitting someone, or doing a robbery, which is a person crime. It's not a murder or a criminal vehicular operation, or any of those things. And actually, it could fall within if you look at some of the felony harassment statutes as well, you can get to a felony pretty quickly there without having, with too many phone calls under the right circumstances, especially I think if you've got a prior harassment conviction or 2, can be a felony. Too many phone calls to the protected party or texts to the protected party, I think, if I remember right, can be felony harassment. And regardless of their history, if the trigger at the end is a comparatively minor offense, it seems to me a statute like this is unfair, not only to the defendant, but unfair to the rest of the system as well, because we'd be locking up a person that would need to be locked up for whatever the upward durational departure length of time is. And it's probably not the best use of public resources either. Unless you fall back on the provision that, well, they're bad people, so they should be locked up because we're not sure what else they're gonna do that's more violent. And of course, we don't lock people up for what they might do in the future. You hear prosecutors sometimes saying that. Certainly if you watch TV, you hear them saying that on TV sometimes. Well, they'll bend the procedures or rules a little bit because they got a bad guy and they're just happy to get the bad guy away in prison. But we don't do that here. We certainly can't do that in the legislature. And this is the problem with these mandatory bills, the ones we've heard before, the ones we're hearing now. Not that people don't deserve punishment for the crimes they commit, but when you have a one-size-fits-all cookie-cutter approach, you inevitably work injustices as well as work justices. And the question is, how many injustices are we willing to accept in order to be more just toward others? And when should the legislature step in as if we are the judge and the prosecutor in the case? And the more we do this, the more we undermine the entire concept of the sentencing guidelines system, which was intended to provide some uniformity in sentencing while still giving some very specific criteria with pretty tight guardrails around for discretion, for flexibility to fashion sentences that seem to fit the circumstances better than any statute ever could. So those are my thoughts. I guess I'm saying some of the same things I said in our previous hearings. There seemed to be a pattern of bills coming before us now as part of the Get Tough on Crime, a process here from the majority that says, we think all the judges, a lot of the judges and the prosecutors are messing up. We don't trust them anymore, so we're just going to tell them they have to lock them up and throw away the key because we don't trust them to use their own discretion. I guess I've got a lot more faith in our judicial system than the members of the majority of this committee certainly seem to have.
Senator Newman.
Anyway, those are my thoughts.
Mr. Chairman, Senator Lance, I would never bring a bill before this committee proposing to lock up someone who, for a crime that they haven't committed or what they might do. That is not what this bill does. What this bill does is proposes to lock up someone who has committed their 6th felony. And at some point, society has a right to be protected against that felon. So I'm not suggesting that we're going to lock people up for something that they haven't yet done. I would also question the assertion that this is a one-size-fits-all. And Mr. Backus can correct me if I'm wrong, but I think I heard him say that there is judicial discretion between what the grid says and the maximum sentence that the judge can impose. And if I'm wrong on that, Mr. Backus can correct me. But I think therein lies the fact that there is judicial discretion and it isn't one size fits all.
Mr. Backus, did you want to make a comment?
Mr. Chair and members, yeah, as I said, in terms of Section 4 of the bill, Section 3 of the bill, the judge does have that discretion. The changes to Section 2, which deals with a different group of offenders, those are the third-time violent offenders, then it's slightly different in that the judge would have to essentially execute the sentence under Section 2 and potentially impose a higher durational departure under Section 1, but those are a different class of offenders.
All right. Senator Bingham.
Thank you, Mr. Chair. And Senator Newman, I'm with you. Don't steal the 6th TV. Don't break the 6th plexiglass. I mean, I'm with you on that. My question is, this is another, it's more of a comment, Mr. Chair, and I'll be brief, but this is another hefty fiscal note. And, you know, your target, Mr. Chair, isn't known for being hefty. So I look forward to when those are released because these bills that are being laid over are starting to add up, sir. And so I just hope if it is your intention to include these in an omnibus bill that you get a hefty target. So, because we don't want them unfunded and putting this burden on an already burdened correctional system where we have a shortage of correctional officers and stuff. So I look forward to that large target that hopefully you're going to be getting here in the coming weeks.
Sarah Bigham, you're reading my mind. There's a reason why we're not voting on these. We're laying them over, keeping our fingers crossed. So, I know we did not have testifiers at this particular juncture, but there are a few things in your packets that you should pay attention to. One is the one that says City News on the top. It's suspects charged with arrest for carjacking, vehicle thefts, robberies, all happening, I think, in one day. And a virtual crime spree all in and of itself. Something that happened in St. Louis Park not too long ago. Actually, this past January is what happened. An individual commit first-degree aggravated robbery, six second-degree aggravated robberies throughout not just St. Louis Park, but other areas. 13 simple robberies, 1 attempted simple robbery, 1 motor vehicle theft, 1 fleeing the police in a motor vehicle. It looks like maybe there were 2 suspects in that case, involving 12 local, county, and state agencies. So we're not talking of plates of glass right now. We're talking of some very serious crimes. The other one is the history of the St. Paul bar shooter that, in the process of shooting at a rival, he shot 14 people. But if you look back on his criminal record, it's quite significant. He had been sentenced for 5 felonies between 2007 and 19. And in those cases, judges gave him lighter sentences in 3 of the cases and did not send him to prison. And if you look on page 3 of that, it's a little more detail. From 2007 through 2019, the presumptive sentence in 2007 was prison. Over the objection of the prosecutor, he received a downward departure with stayed prison time, claiming he was amenable to probation, and he was remorseful. He was credited for time served in the workhouse, for serving in the workhouse, and he was put on probation for 7 years. 2011, drug possession conviction sentence. The guideline sentence was a stay of execution. He was put on probation until 2015. 2017, domestic assault conviction, sentenced to 1 year, which was stayed and released after serving 69 days. It goes on and on. I don't want to bore the audience with all of this, but there was a track record where presumed sentences were definitely recommended, and that particular person did not get the sentence prescribed, but something considerably lighter. And then when he did the shooting, I believe he was a felon that should not have had possession of a gun in the first place. So again, there's more examples than plates of glass. Any other further discussion? Senator Kiffmeyer.
Thank you, Madam. Thank you, Mr. Chair. As I was reading some of these articles and I hear about the repeat offenders, and I think what I want to do here is be a voice for those who suffered during those encounters. What about the gentleman who had his shop 5 times? Supplies were stolen, glass was broken, doors were broken. That cost money to replace it, and it came out of his pocketbook, not the state pocketbook, not the county, city, or anybody else. He had to pay for that. To replace all those supplies cost money. He was in the process of cheering on his wife who was giving birth to their baby boy. In the midst of it, gets a security alert. Leaves her to go and take care of this. He missed his son's first cry, and not able to cut the umbilical cord. These are real things, real harm that happens. Sixth time. It wasn't the only shop that was hit as well. A gentleman who had a store, sneakers, $30,000 worth of merchandise. Interesting enough, it was kind of unique business, 250 left-foot sneakers, 20 complete pairs. He's going to donate the footwear that wasn't gotten by the thieves, shuttering the store, maybe another location. What this also does in that community, they lose that store, that job, that business. The people come there for that and maybe stop at a restaurant nearby as well. These are real people who have real things. And when you've done this and you're into your sixth time, I think as you said, Senator Newman, they're not getting the message on probation. They're not getting all this other stuff. This needs to have a time where serving in prison may get their attention, but if nothing else, for that period of time, they're not out on the street harming real people, costing thousands of dollars of money from people who can ill afford it and their families, and all the consequences that are going on here. I appreciate the fact that we want to be fair and compassionate towards a criminal, tough things like that. What about these folks? What about the fact that they went through a lot of effort to start a business, have a car, all these kinds of things? It is time to say no. If you can't handle yourself, discipline yourself, and stop, then society owes it to all of these people who are being affected by this. We owe it to them to take them off the street and give them a chance to take a look at things and turn their life around. There are numerous stories of people who have gone to prison, and it does get their attention, as the example from Senator Newman. We don't live too far from Sherburne County Prison in our area. We have many local people who go in, job counseling, spiritual counseling, housing, all kinds of things in prison. So it's not like when they're in prison, they're not getting any ability for, or offers of abilities from people who can help them change their ways. But in the meantime, we've got to put our foot down sometime. And I think 6 times is way, way more than I think even doing it. If we can't do it for 6 times, then when do you? I mean, at which point? And not only that, it also says to the others, it's not a big deal. Because probation, you go through the process and you check in and you do different things, but you're basically able to live the rest of your life. Not Mr. Dillon, not these people here. They didn't get to do that. They've got all kinds of things. To tell the truth, I'd rather even put it earlier, because I think the sooner they get out of this way of life, and generally speaking, as I've done some research on this, there are those you're caught for and you're prosecuted. There are other crimes you've committed, you haven't been caught, or maybe haven't been prosecuted, or have been pled down so it's not a felony. So this is certainly a very reasonable bill. I think we owe it to the people of Minnesota that if the judges and the prosecutors aren't going to deal with this and continue to go the route they are right now, then it's time for us in the legislature to say, to protect the people and say, no, you do it 6 times, time to do mandatory prison. Thank you, Mr. Chair.
Thank you, Senator Kiffmeyer. Any further discussion? Hearing none, we will lay this bill over. Thank you, Senator Newman.
Thank you, Mr. Chairman. Thank you, members.
And I'm going to pass the gavel over to Senator Ingebrigtsen, and I'll present the bill from the testifying group.
Senator Limmer, welcome to your committee.
Thank
You
you.
will be
think-
introducing Senate File 3487.
Senate File Number 3487 regards the changes that we're requiring in this bill regarding retail theft. The bill before us is designed to address organized retail crime. Organized retail crime generally refers to professional shoplifting, cargo theft, or the use of retail crime rings, an organization of people. The facts are that 3/4 of retailers saw an increase in organized retail crime in 2020. That's from the National Retail Federation statistics. This bill looks to separate out petty theft and true organized retail crime in Minnesota state statutes. 34 other states have definitions of organized retail crime, and the definitions give those who are dealing with organized retail crime activities modern tools to address the changing way organized retail crime is done today. This bill defines organized retail crime. The language is modeled off of other states and aligns with the closest with Michigan's definition. It establishes different penalties for organized retail crime. Penalties align with the existing statute on theft, but provides enhanced accountability. The trespass language in the bill is similar to a bill Senator Latz had a couple of years ago. I don't know the year, but it was Senate File 738. It amends the trespass notice with language specific to third-degree burglary. The bill also provides a 30-day extension to financial institutions in the service of financial search warrants. Existing statute is 10 days, and this would increase to 30 days. The bill allows financial institutions to release limited identity theft victim information to law enforcement without being held liable for any criminal or civil laws. This bill will have an important impact on distinguishing between petty theft and organized crime. It's a tool for prosecutors and law enforcement. We hope it will have an impact on the organized theft that is going on at retailers of all sizes right here in Minnesota. I've been working with the Minnesota Retailers Association and the Minnesota Organized Retail Crime Association on this bill, and we have testifiers that will give a little better insight on what we need to accomplish in this bill.
Thank you, Senator, and as following suit here, what we'll do is we'll hear from the testifiers and then open it up for questions. The first testifier is Mr. Newstead. Welcome to the committee. Please identify yourself and go ahead.
Thank you, Mr. Chair. Good afternoon, committee members. My name is Bruce Newstead. I'm the president of the Minnesota Retailers Association. We're a statewide network of small and Main Street retailers, as well as regional retailers and national retailers. So I want to thank Senator Limmer for offering this Senate file today, and we actually really do appreciate the hearing and the opportunity to talk about kind of this area of crime. There is a House companion bill to this. It's championed by Representative Stevenson. Mr. Chair, each and every day retailers work in partnership with investigators and law enforcement. One of those retailers that we work with includes not only just retailers, but really financial investigators, prosecutors, and law enforcement. And one of those organizations that brings all those pieces together is called the Minnesota Organized Retail Crime Association, where I serve as a board member. In a moment, you'll hear from Taylor Wickert, who represents that organization, and her colleague is with her today, Cody Johnson, to provide a little context around the issue before you. And you'll hear from Commander Charlie Anderson, who's been a leader on this legislation. Senator Limmer's bill was really born out of a forum that was hosted by the Minnesota Organized Retail Crime Association several years ago at Metropolitan State University, where many organizations came together to discuss sort of the rising problem of organized retail crime and how we really need a different set of tools to address a different set of crime. Organized retail theft, as it's called in the bill, or organized retail crime, as it's commonly called, is an over $30 billion loss a year for retailers, consumers, and communities. As Senator Limmer mentioned, this is a problem that's actually on the rise and not on the decline, unfortunately. And ORC does impact, as Senator Limmer said, retailers of all size, regardless of geography, size, and it costs retailers $700,000 per about $1 billion in sales, according to some national figures from the National Retail Federation. But really, these costs just aren't to retailers. ORC impacts consumer prices, of course, and probably even more importantly, it impacts consumer and worker safety as well. In the end, ORC impacts our communities as well as tax dollars that should be collected through legitimate sales are lost. So, Mr. Chair, I mentioned that ORC impacts business of all sizes. I want to draw your attention to this story that Senator Limmer put in the packet out of Little Canada that Senator Kiffmeyer was just referencing. It's a story of a retail entrepreneur who really did pour his life and that of his life into his store. In the past 5 months, as you've heard, he was victimized 5 different times. Most recently, $13,000 in footwear was stolen. And as a result, he has to close his doors. And his dream is done. Hopefully he's not down and out, but his investment and his time is lost at this point. I haven't talked to the owner or the investigators, but I am guessing you don't steal $13,000 in footwear for personal use. So it's likely an example of some sort of organized retail crime activity. The reality is that ORC today is really a lot different than it was in previous years. I'm sure we've all watched movies of the 50s and 60s and the mob and the syndicate. Organized retail crime is really different today than it was back then, and we just need to update the tools to make the change. So, Mr. Chair, I'll end this like we do with most bills. This bill gets a little bit better every time we talk about it, and so we appreciate the conversation today on this bill. It really is an important step to differentiating, as Senator Limmer said, the difference between petty theft or common shoplifting or even repetitive shoplifting from true organized retail crime. It's time for Minnesota to do what those 34 other states have done and let our ORC criminals know that Minnesota is not open for their business. So, Mr. Chair, thank you for the time today.
Thank you. Thank you for that testimony. Next up, Mr. Rickert, Minnesota Organized Retail Crime Association. Did I say Mr.? I'm sorry, I think it's Taylor. My apologies.
That's okay.
Please identify yourself and go ahead.
Mr. Chair and members of the committee, my name is Taylor Wickert, and I am co-president of the Minnesota Organized Retail Crime Association, commonly known as MN-ORCA. I am also a loss prevention professional with a multi-store retailer, but am appearing here today on behalf of MN-ORCA. MN-ORCA started in 2014 by a dedicated network of law enforcement, crime analysts, corporate fraud teams, asset protection professionals, and prosecutors who had a passion to come together to help identify and shut down organized crime groups that were ravishing large and small businesses, and also often involved with other criminal activity that impacts our communities. Prior to MN-ORCA, retailers and law enforcement worked independently and were oftentimes not successful with closing these large cases as there is a limited visibility to the extent of these groups. Once MN-ORCA came together, public and private sectors were able to close the gaps and gain better insight into the broader impacts that these groups were having. And while these partnerships have allowed our state to become more successful with closing these cases, there is still a need for a differentiator between simple theft, for example, a parent stealing to provide for the family, and these organized, intentional, sophisticated, and sometimes international crime thefts, or criminal thefts. It should also be mentioned that while we often think of the impacts to larger organization, for example, not paying for and exiting stores with carts full of power tools, vacuums, gaming systems, etc., from large organizations, it is critical to understand the crippling impact of these losses to the small businesses that have fewer resources to combat these losses. To put this in perspective, retailers are losing on average $2,000+ in each theft occurrence from these groups, adding up to an astonishing over $700,000 per $1 billion in sales for large organizations, and an even larger impact to these smaller businesses. MN-ORCA fully supports this bill as it would clarify the difference between a person engaged with petty theft versus these groups or individuals that have the intent to defraud businesses for their own personal gain. Senator Limmer, thank you for this legislation. And Mr. Chair, thank you for the opportunity to discuss ORC and its impact on Minnesota.
Thank you very much. Next, we'll go to Commander Charles Anderson. Welcome to the committee.
Mr. Chair, thank you. I am Commander Charles Anderson with the St. Paul Police Department. I have been involved in law enforcement for 15 years. What Senator Limmer and Mr. Newstad and Ms. Weichert have testified to, I don't know how much more I can add to it other than to say that in charge of the Crimes Against Property Unit for St. Paul Police Department and the men and women investigators that are understaffed and overworked, these type of tools that differentiates simple and petty theft from organized retail crime, the ability for us to investigate identity crime and the victims that deserve justice, as well as making sure that our burglary statutes are appropriate in regards to trespassing, as well as recognizing that our financial institutions need to be given the latitude to produce information for financial and fraud investigations in a timely way that doesn't encumber them, not only makes our job as police officers better and more valuable to the victims that we serve, but also gives prosecutors the ability to prosecute these crimes, understanding the latitude that this gives them and the ability to hold criminals accountable for the types of crime that have been explained in this bill. I strongly support this bill, and I would ask for the committee's support as well. Thank you.
Thank you very much. And with that, I'll ask if anybody in the audience would like to speak for or against the bill to come forward. Sir.
Mr. Chairman, members of the committee, my name is Rich Newmeister.
Welcome to the committee.
I just want to bring to your attention on page 7, subdivision 8. It's more of a technical point, but it's an item that can be resolved if the bill's going to be laid over. On lines 727 through 730, you ask for a release of limited account information to a law enforcement agency, and you place it confidential. Confidential is information that is, and it's not mentioned a lot in the Data Practices Act. In 1382, when you look at that section of law that deals with law enforcement data, it's only used 7 times. Confidentiality when an investigation is happening, confidentiality of a reporter's name and vulnerable adult or child abuse information, confidentiality of a name in terms of an informant. So, and if you look at 1382 subdivision 30, you'll see that it is considered private account information. This was done several years ago because account information. But to have a name of a victim be confidential is something unusual in these kind of circumstances. Victims' names are private throughout the statute, sexual assault and other kinds of situations. So it's just an area that I would like to encourage us to take a look at. There can be input from folks. I know Minkoji is involved, not with them, but they do a lot of work on these kinds of issues. So as the bill goes forward, which I think is a great bill, I'd just like that section to be looked at so it does not become a new thing that people all of a sudden, well, this is confidential, so therefore let's do this. Thank you, Mr. Chairman, members of the committee. I'm much obliged to you for your few moments.
Thank you, Mr. Newmeister, for your testimony.
Mr. Chairman.
Senator.
Mr. Chairman, I want to thank Mr. Newmeister for pointing that out. Confidential is usually used as a reference to, well, in this case, the closest would be a criminal investigation. That data collected by a law enforcement agency would remain confidential until the case is closed. But however, in this case, under paragraph E, starting on 727, it kind of tracks the investigation, and as it tracks the investigation, the definition could change. And I was wondering if perhaps council could, well, do we have our civil law researcher here? Because that really gets into this. So I see that she would not be on, so we'll have to remain in in repose on that, waiting for a better definition. I think Senator Newmeister might be onto something here. So as we continue, as is known, we're laying this bill over, so we'll have time to investigate. Mr. Chair, I will stand for discussion.
Okay, open it up for discussion. Senator Kiffmeyer.
Thank you, Mr. Chair. I was noticing this as well and reading through it, but this is in regards to the victim. So this subdivision, potential victims account. And so it seems to me that we would want to protect the victim's account, that the financial institution releasing this to law enforcement is for the purpose of necessary information in order to gather information. So I'm looking at this, that this applies to a victim, and that context makes a difference. So if I'm reading this incorrect, but maybe either counsel or somebody else can.
Mr. Chair, Mr. Newmeister would like to answer your question.
Okay.
If that's okay.
Mr. Newmeister, welcome back.
Mr. Chairman, Senator Kiffmeyer, generally victims, just in general, under 1382, you have in law, there's a panoply of where victims' names are considered private. Generally, in financial information, victims' names are generally public, except if it fits under one of those categories. Information that relates to financial accounts, like their account numbers, all those kinds of things, are not public. So where you're putting victims' names under that are of identity theft, that's different than in general kinds of ways. So the general flow of the statute is victims and witnesses' names are public except for certain categories. And there's about 14 of those different categories, maybe a little bit less. And those are in statute. If you do this, it's just a different kind of thing where you now are going to say victims' names of identity theft are confidential, which is a different issue, a different thing. There has been debate over the decades, should victims' names be public or not? And so with our approach under the law, you take a look what is being asked for, and you make a decision. And that's why there's a number of victims' names will never be public, they're private, which is different than confidential, which means nobody has access to it. Even the victim themselves won't have access to it. So it's just something I just wanted at least to share. And Mr. Chair, Madam Senator Kiffmeyer, I only bring it to the attention because sometimes my long history here of being here for public access and accountability, something that's done in law will sometimes come back as being the scenario or point of why we make a lot of other things not public, whether it be good or bad. That's for the legislature to decide. So that's why I'm just pointing this out.
Senator Kiffmeyer.
Thank you, Mr. Chair, and I do appreciate that very much, focusing our attention on this. And I heard your comments, and I gave it careful thought. But in this particular case, I'm trying to think of what would be the public good of having the name here be public, right? You got to have a reason to make it public, or public right to know, or public benefit, or something like that. In the case of identity theft, I do not see where there's a public good or value in it. And I understand that maybe this doesn't fit in one of those 14 things, but they started out with probably nothing and then added 1, 2, 3, 4 to 14. Maybe this is another one, whatever it is. I just look at it and say, I don't see what the public good is for making this public information when the criminal investigation is over. We had a personal check and a business check stolen out of our mailbox. It took me a long time to get my name cleared. Having another situation where some of this is public data would be my concern. I also see that there's somebody else who may want to weigh in on this, Mr. Chair. So I'm glad to hear more.
Mr. Chair, Commander Anderson would like to speak on this. We're now getting into the area where the cult of data privacy now emerges. And so it gets complicated, but at the same time, for those of us, we've categorized certain types of information to be placed in certain categories. And if we start stretching and blurring the line, it really creates a lot of problem for revisers and everyone else.
Commander Anderson, welcome back.
Mr. Chair, Senator Kiffmeyer, Senator Limmer, thank you. Real quick, I need to provide a little context, and maybe I just needed some time to make sure I signed in as a testifier. But the reason, to give you an idea, under the identity theft statute, you have to be able to actually identify a victim in order to get to different statutory limitations. So oftentimes, our investigators will receive maybe information on one victim, and maybe we have that information that we need to move forward with one victim. But we have a whole list of account numbers of people like you, like me, like our citizens that have no idea that their accounts are being drained, that their identities have been stolen. My in-laws lost over $60,000 in a scam. And if this bill would have been law, there's a chance that they could have been warned beforehand. When we get those account numbers, we don't have anything to go on. They're just simply numbers. What gives us the ability is to take a case where we have maybe one victim that we know their name, we know who they are, but then it gives us the ability to reach out to our relationships that we've started with corporate law enforcement, corporate investigators, financial sector, specifically banking, say we have this account number. We just need their name, maybe their address and their most recent phone number so that we can identify them as a victim. Let them know that they're a victim, make sure they're protected, and include them as a victim when we obtain that case file that's going to the prosecutor. And now instead of one victim where we know we have tens, hundreds more, now we know we can get to that threshold of 8. And we don't have that ability to do that in a timely fashion. Currently, we need to have the bankers the ability and the financial institutions the ability to get us that information in a timely fashion. How that victim's data is classified, whether or not it's confidential or private or public, that's Senator Limmer's job, and I trust him and other folks to understand what that means. All I want to do is be able to give my cops, my investigators, the resources to protect as many people as possible, and that is a specific type of situation where this language would help us to do that. I hope that helps.
Mr. Chair, I'll just finish up with this.
Senator Kiffmeyer.
Absolutely. I absolutely understand that on your portion of it. I think the only thing here is down on line 7.27 was, once you've used it for all valid purposes, it becomes private again, as it was in the beginning. To them, it becomes private again. So the in-between time, perfectly fine. I would want that. Would welcome that, because I know you've got to have that in order to do your work. I think what Mr. Newmeister was bringing up was on the very end there, categorizing it as private once all of that is done. So we don't want to impede you in any way by what you need in the earlier part of this section 6. It's just classifying it as private once again. And I would say the biggest thing here is it started out as private, and it should be private again once the investigation is done. And I think that's protecting, I think, the victims, because once those things become public, I mean, it exposes them to what purpose, what's the public purpose or good there. But I appreciate the discussion, and appreciate your comments as well. Thank you for your work.
Thank you, Senator. Couldn't agree more. Thank you.
Mr. Chair, we'll confirm with council on that so we get the right category.
Anybody else, either for or against the bill? Seeing none, any questions of the author? Senator Limmer.
Well, Mr. Chair, we have the bill before us. We're going to lay it over. And If anyone has any further questions as we do our reading and research on this particular idea, we'll certainly be open for further questions.
Thank you, Senator. So Senate file number 3487 will be laid over for possible inclusion. Thank you, Mr. Chair. Is there nothing else?
Mr. Chair,
before we go to
there's
the
no
order?
further business before this committee. I suggest we move to adjourn.
We are moving to adjourn.